Hello, this is Rob Lambert with AssetProtectionTraining.com. Today I'm honored to be able to moderate a collegial discussion between two superpower litigators. One will be trying to pierce a well-done asset protection plan, and the other will be trying to defend a well-designed asset protection trust. Our two gladiators, who are both good friends of mine, are Paul Brown and Randall Edwards. Here are our boys. Paul Brown on the left and Randall Edwards on the right. I have personally been represented by both of these men. They are people that I trust, I know well. In Paul's case, he's probably defended way over half a dozen of my clients, way over $500 million of money, some of it almost unlimited budget litigation, and 100% success, and he knows how to defend an asset protection trust. He also knows how to break them. He and I have gone offshore several places to attack. Same with Randall. Randall has represented a substantial number of my clients, all with 100% success. One of them, still alive and kicking, had more than 1,000 properties in foreclosure, and that worked out well for our client. Randall and Paul are collegial with each other. Paul, they drew straws. Paul is representing the debtor, the person who has the asset protection trust, and Randall is representing a huge Fortune 100 company trying to destroy or to collect on a large debt. Paul and Randall, do you want to say anything about yourselves before I go over the fact pattern of the War of the Worlds?
I'll defer to Randall first, and then depending upon what Randall says, I'll follow up.
That's perfect. Yeah. My name is Randall Edwards. I'm a lawyer. I have been for the last 30 years almost. I practice in Salt Lake City, Utah. I have offices here. I also am licensed to practice, aside from Utah, in Nevada and California and Arizona. I also have an affiliate office in Brazil. I do a lot of international work, mostly in Latin America. I speak Portuguese and Spanish. I spend a lot of my time either on the phone or on Skype discussing various matters with my South American clients. My experience is that of generally a litigator. I've been a litigator since I got my law degree. I've always believed that in order for you to be a good transactional lawyer, you probably also need to know your way around court. Every time I put together any kind of a transaction, whether it's an estate plan or an asset protection plan or a contract, I start with the presumption that somewhere along the line it's all going to fall apart. And when you do that, you have to kind of say, all right, when it falls apart, what am I going to do? How am I going to put it in front of the court? How are 12 people who are, as one of my cynical judges put it, too dumb to get out of jury duty, how are they going to be able to understand this in such a way that I can make it work? And so I think that usually in order for you to make something work, you need to be able to break it down in such a way that somebody who doesn't know anything about your case, anything about your client, will be able to understand it, and you can let them figure out how it is that things should be done. So that's kind of my background. I think that you can probably look up my resume there on the AssetProtectionTraining.com website, and I will now defer to Paul, who I also know happens to be a very good litigator and a very good planner as well.
Well, thank you for those kind words, Randall, and the segue. Yes, my name is Paul Brown. I'm a partner at the Seattle firm of Carr, Tuttle, Campbell. I've been practicing, I can't believe it, over 20 years. I had someone ask me one time, why do you keep on practicing? Don't you ever, perfect your craft? And the answer to that, quite honestly, is no, because things are changing so often and so much. The primary focus of my practice over the last couple decades has been litigation, both onshore, offshore, complex commercial transactions, financial fraud, both defending and in piercing and recovery. I, too, like Randall, and I think Randall, not to sound like we're too collegial, but his perspective on being a good transactional lawyer, understanding litigation, also works the other way around. I've done a lot of transactional work in my former life, offshore, primarily with raising funds and investment banking work in Taiwan in the late 90s, early 2000s. And after that, I had the opportunity to do more asset protection work, as well as recently in the last 5 years, I've done a lot of asset recovery work. So I guess I'm your quintessential litigator, and I'm a switch hitter, if you will, and as crude as it may sound, the one-night stand type lawyer, go in for the particular problem, fix it or take it or deal with it, and then, you move on to the next. I think Rob and I do have an interesting history, and years ago in one of our matters we talked about how we would identify what we were doing. And really what we were doing, in a way, and with no disrespect to law enforcement, but to keep in perspective, we were a legal SWAT team. Very mobile. We were able to compile a team of experts, forensic accountants, international tax people, estate planners, and litigators, and then with Rob being the forefront on the structure issues, and we went into a particular area, state in our country, and did just that as a SWAT team, and we're successful in that matter. That's kind of how I would craft, if you will, or identify my practice. With that said, the other thing I think that's important to understand, and I know Randall and Rob would agree with this, while we zealously represent our clients, while we are an advocate, we are warriors and gladiators. One thing I will not do, and I know Randall would agree as Rob, we do not engage in unethical behavior or conduct. And our ethics are higher than what our bar associations require. It's important that clients understand full disclosure is necessary, so we understand what the problems are, and then we can address them. But things that are hidden and it's not full disclosure, we can't help those people. And sometimes we do represent people that have problems and need to be dealt with. But when we have those disclosures, we can deal with them, in an effective manner. So I just kind of say that as a footnote. It's important that those that are listening understand that the ethics and morals of our practices are first and foremost and are pinnacle to what we do. I go to bed at night knowing I do a good job, but I don't worry about doing something that is improper. I will not do that. So there's my little tidbit.
Okay. I was going to add to that, Paul. We've talked about this before. There's also an aspect to any law practice where ultimately you have to like the client. I mean, they don't have to be your best friend, but you also need to be in a position where when they either give you a call or walk in the door, you don't just shudder. I had a case not long ago, a fellow in one of the jurisdictions that I practice outside of Utah. He called me up. He was a doctor, and he says, look, I've been married to this woman for the last 30 years. I'm sick of her. I've got somebody else. I want to get out of the marriage. I just want to get out of this thing, and basically I don't want her to get anything out of it. I put some money away here and I put some money away there, and yeah, we've got a couple kids together, but basically I want to hose her. And he said, now can you help me? Well, the answer to the question from a legal standpoint was, yeah, there are probably a couple of things that I could do to help you, but I just can't stand what it is that you're doing. I can't stand what it is that you want to do to this woman who is the mother of your children. Yeah, I could probably do something for you from a legal standpoint, but from an ethical standpoint, I can't do it. You're going to have to find somebody else. So best of luck, but I'm not going to be the guy who's going to be representing you trying to really undercut this woman that has stood by your side for all these years simply because you happen to find somebody else later on down the line.
Yeah,
I couldn't agree with you more on that as well, and I think that that is very well said. I do get lots of calls. I don't take everybody who calls for that very reason. I think if you don't embrace and like your client, then you cannot be passionate about what you're doing. And I think, Randall, you would agree with this. Judges and juries smell that. And they also smell, and there's a sense when you have a passionate advocate that believes in the cause that they are advancing. And that is very, very important as well.
Yeah, we'll talk about this a little later on, but motives matter. They matter to juries, they matter to judges, they matter to lawyers, because in the end, it isn't just a matter of a bunch of written words on a page that just fell out of the sky and we look at them and apply them like you would a, let's say, a gumball machine. You put in your quarter, you pull the lever, and then out comes the gumball. Well, a lot of people think that that's the way the law is. You know, they put in the facts, they pull the lever, and somehow the result's going to come out. Well, no, you're dealing with human beings, and if the jury or the judge comes to the conclusion that your guy just isn't that savory, or he's just not being fair, or he's trying to screw the poor creditor out of whatever it is that he signed up for, knowing full well that he was going to do it, it really doesn't matter what the law is as far as the letter of the law. They're going to find some way that their sense of justice and fairness and equity is going to be served, and I think that that's also true of any lawyer. There are some lawyers that I know who will take anything as long as the guy can pay the bill. I'm not one of those. I know that Paul's not one of those, because motives do matter, and they ultimately matter in any kind of aspect, and it doesn't matter what you're dealing with, whether it's a divorce or a business aspect, or you know, whether you've got somebody in a personal injury, a medical malpractice case. I mean, motives will matter to the point that if you can't believe in it, you're not going to be able to get a jury to believe in it. You're not going to be able to get a judge to believe in it.
And, you know, that segues, interestingly enough, I think, to our fact pattern here. While I do agree with that perspective, I also think that in my former days, I used to do criminal prosecution decades ago and then some criminal defense. I mean, I have no problem in requiring the state, you know, in a criminal matter, requiring them to meet their burden. Same thing in a defense of an asset protection challenge. I have no problem in making sure that the plaintiff has to meet their burden. I think that keeps a good balance in place, and also, you know, segues into the Shakespeare quote that's always misquoted about the first thing you do is kill all the lawyers. Well, in the proper context, if you read that, I think it's out of King Lear, and those that are listening, if I'm wrong, please correct me on it. But if you want anarchy, that's what you do. And the point is there's a balance that's being made here too. And I think the fact pattern we have before us, one may think and assume, I guess, and assumptions can be bad here, but assume when they look at this that Randall really is representing the justified party on this, and I'm representing, you know, the for lack of a better identifier, the scumbucket. And I beg to differ with that, and I think as we go through our discussion, you'll see my point much clearer. With that, I think maybe, Randall, if you're done, Rob, you want to do your job, and let's move on.
Yeah,
well, I did want to just correct one thing. I have read that Shakespeare play, and I thought it was the first thing we do is kiss all the lawyers. I guess I better read that. Anyway, go ahead, Rob, and kind of introduce what the fact pattern is, and we can go at it.
Yes, sir. And Randall and Paul are both right that good asset protection and good litigation never requires you to be immoral or unethical. And it's never stealth. Stealth helps, but you never have to be unethical, lie, cheat, or steal. And here we go. This is the caveat that both of our fancy and wonderful litigators have asked me to show to you. Bottom line, don't believe a word they're saying. They're not representing you. They're not rendering any legal advice. Don't sue them by relying upon what they say. Hire somebody good.
Or for any other reason.
Yeah, or for any other reason. You just read this yourself. I don't want to read it to you. But now you're done. Here are the facts. The facts. I'm going to read it to you. Paul Brown represents a newly minted internet millionaire named Joe Nerd, now Mr. Nerd. Mr. Nerd just received a patent which he thinks will change the face of mobile computing. And he sold this patent to a company we're calling Big Co, a Fortune 100 company, and he sold it for $50 million cash. In connection with this sale, Mr. Nerd signed numerous representations and warranties, including one that he had clear title to the patent and the power to transfer it. Mr. Nerd agreed to work for Big Co for 2 years following the sale and to remain in California where he lived during this time. Very common provisions. The patent was bought with a single payment of $50 million, Prior to this sale, Mr. Nerd settled an asset protection trust in Belize. For this discussion, you should assume he had no problems, no creditors, just a brain. He put $5 million cash into a Belizean bank, $40 million into a major Swiss bank, and bought a $5 million home in Beverly Hills, all owned by his asset protection trust. The trust had a single Belizean corporate trustee, an English barrister as the protector, and Mr. Nerd and his heirs as the sole beneficiaries. Almost done. Then, at that time, Mr. Nerd did his planning because he wanted to get married to somebody I'm calling Fanny and start a family. He wanted to protect his hard-earned money from future unanticipated creditors and his new wife. Everything went along fine for a few months. Fanny fell more deeply in love with Mr. Nerd, became a Pilates instructor, and started taking acting lessons. Also very typical. Big Co, excited about the new technology, proceeded with the development of a new type of mobile phone until another giant company, where I'm calling Phone Co, notified Big Co that the technology for the patent actually belonged to Phone Co, as the original idea was developed when Mr. Nerd was an intern at Phone Co. Upon investigation, Big Co determined that Phone Co just might be right and that the development of the new mobile phone had to stop. Mr. Nerd had breached his representations and warranties. Big Co's board was furious and hired the biggest, baddest, meanest, most expensive Simon Legree litigator in the world. Randall, no surprise, that's you.
I'm pretty thrilled about that.
To get their $50 million back. Their instructions: get our money at any cost, don't care, win. As long as, that's typical of boards, they spend money. If they hire a big fancy enough firm and spend enough money, it's hard to accuse them of not taking care of their ethical duties. So they hired Randall Edwards, gave him an unlimited budget, and said, go get Mr. Nerd, who was represented by Paul. So assume in this litigation that each party has an unlimited budget, each party is well done, each party has right on their side, and as many of you watching this will see when you hear the discussion from both sides, there's a lot of decisions, there's a lot of strategy. Either party can win. There's no such thing as an unpierceable asset protection trust, and there's no such thing as an absolute predictable outcome. You guys are all going to be blessed when you hear these two amazing litigators talk about how to discuss this. Now, here's a diagram that I'm going to put back on the screen once the Paul and Randall start talking. And you can see we have right here Mr. Nerd, the protector. That'll be important maybe. We have a Belizean trust company, a single trustee, not a kinetic plan with two. We have an offshore protector who's an English barrister. And down here you'll see at the bottom we have the assets. And this square just represents his trust. You have a very simple structure. Now, I'm just going to put this next slide up for a minute while you can see it. Paul's representing Mr. Nerd. Randall's representing Big Co. They'll be dealing with who to sue, where to sue, theories, expectations, budgets. I'm going to not suggest anything to them because they've been through it a million times. You'll find all sorts of other issues coming up. Now I'm going to turn it over to our two geniuses and just be here. I'm the judge, by the way, in case they need to take anything to court, and I will render a judicial decision if they bring anything to me. Otherwise, I'm going to be quiet. Okay, guys, take it away.
Well, I think that the first thing we need to clarify, when you call me a genius, I always get a little worried, not because I actually am a genius, but because I don't actually work at the Apple store, the only place I know where you can get paid for being called a genius. There's a couple of things that we need to indicate to our listeners at the outset. This is going to be more kind of a couple of guys as if we were in a conference room in our respective offices batting around ideas. I just did this yesterday, as a matter of fact, with one of the lawyers with whom I share some office space. We were trying to figure out a very complicated statute of limitations issue, and we one of us took one side, one of us took the other side, and then we sort of switched sides as we went through it just to try and analyze where things are. The first thing I would say, if I had been hired by Big Co to represent them to go after Mr. Nerd, I'd want to make sure that they understood that this is going to be an extremely expensive and time-consuming process. No one should ever be under the illusion that to break an asset protection plan is either simple or that it's cheap. Even one that's not put together particularly well, and let's presume that this one is put together pretty well, even one that's not very well put together is going to have its challenges. You're going to have to sue in this case, various jurisdictions, but even if you only have to sue in one jurisdiction, it can be a very difficult situation. I can see that you've got the graphic of the trust up there. And for the listeners who may be unfamiliar with a trust or how they really work, and you'd be surprised, I actually sometimes have to educate judges on how a trust actually works. They took a course somewhere along the line in trusts and estates 30 years ago when they were in law school. They really weren't listening. They were staring at the girl in front of them. They really don't understand it. And I always explain it to people in very simple terms. To me, a trust is nothing more than a day at the beach. Let's suppose that, that I've got Rob Lambert and I are hanging out on the beach together. And I say, hey, Rob, I'm going to go around the corner down there. I saw some girls in bikinis that I want to go look at for a minute. My wife's going to be here in a couple minutes. And what I want you to do is when she gets here, I want you to take this suntan lotion and give it to her. And Rob says, okay, that's great. I take off down the beach, and Rob hangs on to the suntan lotion. At that point, a trust has been created. I am the grantor of the trust. I am the guy who's giving something to the trust. Rob is the trustee of that trust. He's the one that I've given it to. But I haven't given it to him to use for himself. I've given it to him for the benefit of someone else. My wife is the beneficiary. And when she shows up, she will get the suntan lotion. The suntan lotion is the corpus of the trust. So you've got me, the grantor. You've got my wife, the beneficiary. You've got Rob, who is the trustee. Now, as you can see, if you look at this graphic up there, there are also a couple of other things that you don't often find in this kind of really simple trust, and that is at the top you'll see protectors. Now, most trusts that are put together in the United States, for example, if you have heard of a living trust where you put your assets into a trust so that you can help the succession of your assets as an estate planning thing, you won't necessarily have a protector. But in a lot of asset protection trusts or trusts that deal with offshore entities, you will have a protector. And what that is that's just kind of a second insurance policy. That protector sort of sits on the trustee's shoulder and makes sure that the trustee is doing what he is supposed to be doing. Here we have got an offshore protector that is in Britain, and then we also have another one that is actually Mr. Nerd. Now, back to my beach analogy, if we had, let's say that Paul's on the beach with us, and I say, hey, listen, you know, I know that Rob is a forgetful guy, and when my wife shows up, he's going to be so dazzled by her brilliance and beauty, he may forget to give her the suntan lotion. Will you make sure that he does that? And if he doesn't, will you find somebody who will? That's actually usually what a protector does. They sit on the shoulder of the trustee, and they make sure that they do what they're supposed to do, but they don't have any powers to do it themselves. Usually what they will do is they have only very limited power, and that power is usually to either get rid of the trustee and appoint somebody else, or to make sure that the trustee is actually carrying out the duties that they are supposed to be doing. Now, let's get down to some of the things that we would do. The questions that you ask: who to sue, where to sue, what are my theories, what are my expectations? Well, all right, we get down to what the who to sue. Well, obviously, it's not so much a matter of who to sue as much as what is it that I want. My company has given me a specific goal: get our money back. Well, how is it that I'm going to get the money back? Obviously, the obvious person that I want to sue is Mr. Nerd. Mr. Nerd is the one that I'm going to claim had defrauded me, and that he had misrepresented, and that he has actually, I mean, he's taken stuff that he's not entitled to. He's got $50 million of mine that he shouldn't have, and that not only that, he's compounded that by taking that money and hiding it so that I can't get to it. Well, I can sue him, but if we look back at the at that structure, there we go. We look at that and we say, well, wait a second, that's nice, but if I get him, what am I going to get? Well, let's look at what he's got. He's got a $5 million home in the United States. He's got $5 million in a Belize bank, and the two big banks in Belize, I dealt with both of them, are the Bank of Belize and Provident Bank. It's going to be in one of those, or maybe a combination of the two. He's going to have $40 million in the Swiss bank, and there are a ton of Swiss banks that I know that Rob has had a lot of experience with. Well, what I really want is I want the money. I don't necessarily want Mr. Nerd's hide. Having him tacked up on a wall isn't going to do me any good. Well, what can I get immediately? Well, here on shore within the jurisdiction of a court, there's only one asset there that I can immediately get, and that is his home. So I can sue him in California. I can try and get an injunction against him, and I'll talk to you about what the elements of an injunction are in just a minute. But the only thing that really I've got immediate access to are his home, and let's go ahead and presume that that $5 million home actually has $5 million worth of equity in it. Now, there are some things that I thought...
Randall.
Yeah, well, exactly. That is a big assumption. And it could well be that...
Let's assume that assumption is incorrect.
Okay, all right. Yeah, let's presume that he bought the house for $5 million, but that he's got liens of $4.5 million against it. There's only $500,000 worth of equity, and he may be able to take advantage of a homestead exemption. Every state in the union has a homestead exemption, some very, very generous, such as Florida and Texas, where there is no amount that is not exempt for your home. Some very stingy, such as the jurisdictions that I practice in. Utah's homestead exemption is just pathetic. I think it's $20,000. And so it may well be that even if he's got his Beverly Hills home, there's not going to be much that I can get. And frankly, I'd much rather get cash than to get a home anyway, especially in today's market, because a home is going to be difficult for me to liquidate. Big Co can't really do that much with a home. They may be able to turn around and try and sell it even if they were to get it, but that's not a really wonderful thing to get. So then we look at, well, what are the other things that I can get? I can go after his $5 million in a Belize bank. I can go after his $40 million in a Swiss bank. How is it I'm going to be able to do that? And actually, I got to tell you, Paul Brown has had quite a bit of success in doing precisely this. You go after what's known as injunctive relief. Now, let me explain that in sort of terms that the average Joe can understand. If I am shooting at your house from my house, there are two things that you can do. You can sue me, and you can say, I want to get damages. I want to get money for all the damage that you've done to my house. I want dollars for that. But the other thing, the thing that I'm most concerned about is, I want you to stop shooting. You could really do some massive damage to my, you could hit somebody. You could hurt somebody. So you could go to court, and there are two avenues there. The legal avenue, the remedy at law, is I want your money. The equitable remedy is I want you to stop shooting. Now, the American courts have jurisdiction to do both of those, and often they will not give you an equitable remedy if they say that your remedy at law is adequate. Well, you sue me. I go in and say, I don't want to stop shooting. You've got an adequate remedy at law. If I kill somebody, you can sue me for wrongful death, and you can get whatever it is that I've got. You say, well, that's not good enough. That's not an adequate remedy at law, because I don't want to take the chance that somebody's going to be killing me. Well, when you look at this kind of a situation, you go in and you ask the court for an equitable remedy, and in this case that would be an injunction. Well, where do you go? You'll notice that at the bottom of that page you've got some of the money is in Belize, which is outside the United States. Some of the money is in Switzerland. You can't go to an American court and try to get any kind of remedy from them, because they're not going to have jurisdiction over a Swiss bank, and they're not going to have jurisdiction over a Belizean bank. Now, there are a couple of things that we'll talk about a little later about what things you could do in the United States, but let's just talk about going to the money right now. Well, there's a legal remedy where you go to the courts, and then there's sort of the practical remedy. The legal remedy is that you could go to a court and try and get what's known as a Mareva injunction, M-A-R-E-V-A. That comes from a case that is from the British Commonwealth. And essentially what you do is you go in and you ask a British court to issue an injunction that will freeze all of the assets. It's actually called, I think, a freeze order. The Moreva injunction comes from a case that was called somebody versus Moreva or Moreva versus somebody else. And there have been various places that has been very successful. In fact, there was a case, it was 3 or 4 years ago, where ExxonMobil got a Moreva injunction against a Venezuelan oil company, and they got it for, I think it was billions and billions of dollars. And you just go in and you freeze all of the assets. And you say, okay, they can't move it, they can't do anything with it. Those assets are going to stay put where they are until I can figure out where they ought to be. Now, there's a couple of problems with that. The first one is they're very difficult to get. The second one is going to be jurisdictional. As far as getting an injunction, you have to go in and essentially prove your entire case right at the outset. You have to be able to say, I'm entitled to judgment. All of the equities are on my side. What this guy did was wrong. He is way out of control. I'm entitled to judgment, and you better freeze those assets, because if you don't, he's going to take them, and I'm never going to see them again. And in order to do that, you have to go in, you have to get that from a court. Now, I'm going to defer right now to Paul a little bit to talk about what the defenses would be to a Moreva injunction.
Well, I think there's a whole bunch of stuff going on here. That's legal for, in Latin, for a whole bunch of stuff going on. Randall, have you already sued my client in the United States?
I don't know the answer to that. The answer is maybe. And
Okay.
let me tell you from my aspect, from a tactical standpoint, why I may or may not want to do that. The one thing that I don't want to have happen is for him to move the money to a place that I can't get to. Let's say that I know somehow, either through answers to interrogatories if I have sued him, or I found out some way, that I know where the money is. Well, usually these trusts are going to be so flexible that as soon as there is a whiff that somebody may be out of it, may be wanting it, the trustee can move it. So that $40 million may be in the Swiss bank today, and it may be in the Cayman Islands tomorrow, and it may be in the Cook Islands the next day, and it may be somewhere else the next day, in such a way that unless I freeze it, I won't ever be able to track it down. So it may well be from a tactical standpoint that I either do or do not want to sue him, simply because I may not want him to I may not want to give notice to him that I'm on his trail and spook him so that the trustee moves the money.
So if you do sue him, he does have that notification, and within the trust document, I think there's a betting chance that where you're looking for the money, it ain't there, to be very simple.
I agree. Yeah, I agree.
And I also, they go on red alert status. We've got the duress clause. The protectors are changed. The new protector can now change beneficiaries under the instrument. The trustees changed, and we're saying go run around. But I think fundamentally there's a big problem that plaintiff, Big Co, faces here. And that is, was the structure initially effectuated, if you will, in an appropriate manner? In other words, did Mr. Nerd set up his offshore trust properly to begin with? And is there a threat that we need to be concerned of whereby there can be an attack on the structure itself? And based upon the facts, as I would spin them, I would say Mr. Nerd set up his offshore trust, and the fact pattern says we've got unanticipated creditors at the moment. There was nothing threatened, pending, or expected at the time. Therefore, he set the trust up for wealth succession and estate planning purposes, not to defraud in any shape or fashion any legitimate creditors. And it's interesting to say, well, he should have anticipated there could be a creditor through Big Co. And that the operative term on this is legitimate creditors. And I would argue there are no legitimate creditors that can unwind this offshore trust at the time that we set it up.
Let me jump in for, oh, I'm sorry, go ahead.
No, go ahead.
Okay,
Okay.
I was just going to jump in and talk about that issue. I think you're right. That is a fundamental primary issue. Is the trust going to be valid? Your argument would be, and this would be the argument I'd have if I were representing him, there were no anticipated creditors, certainly nobody legitimate. He simply put this thing together in anticipation of getting married, and he knew that there might be some nebulous creditors out there, but is that going to be enough? If I were representing Bigco, which in this case for our purposes I am, my argument would be he knew that there was at least going to be a legitimate claim by them when he started stealing their technology, and he certainly could have anticipated that this big old company that he has been working for, that he sees in litigation all the time, was not going to put up with that and was going to go after him. And so he was trying his best to try and undermine that. It gets back to the issue that let me just finish and then you can go ahead. It gets back to the issue, of course, of motives matter. If Paul is successful in saying he had no ill motive when he put this thing together, I think that he's probably got a good chance of having that trust hang together. If I can say, wait a minute, his motives were bad. His motives from the outset were to try and cheat these people and then hide the money and try and get them from getting to it, I think there's a much better chance of being able to unravel the trust.
And I think that your burden, though, on that is going to be significant, and I'll address that in a second. But first, let's go to another fundamental barrier, as I would call it, barriers to entry, okay? I would also argue that Bigco's trying to take the easy way out on this mess, and really, we've got a whole bunch of problems in the intellectual property issues. And the dispute at the moment is PhoneCo and Bigco. And we're also making assumptions, huge assumptions, on the validity of the patents that need to be challenged, on the validity of the technology, on the issue on whether or not Mr. Nerd is indeed the inventor. They need to have challenges on that. Are they going to try to invalidate the patent at the USPTO? Because I think the fact pattern talks about the patents are issued in this technology. There are going to be multiple fights on that. We will hire great IP litigation counsel to make those arguments, and quite frankly, I think those are legitimate defenses that we can also use to support our contention that the trust was set up validly, and it was set up with the intention of estate planning and wealth succession purposes, and it was set up with the intention to provide for the future family of Mr. Nerd. It had nothing to do with PhoneCo and those problems. And if it did, okay, fine. We've got a few million we could throw in the pot to have you go away, but you're not getting that 50 million. That has nothing to do with that problem. And the issue, the pinnacle issue on whether or not the money was procured vis-a-vis some kind of fraudulent activity hasn't been adjudicated at all. And if it is adjudicated and we lose, we will appeal that and post a supersedious bond. You're nowhere near offshore at the moment. You need to stay onshore with those issues. At that time, we've got notice of those problems. We've gone on red alert status, and the money where you think it is doesn't exist. It's not there. That would be barrier number 1 through 3 probably. Okay.
Go ahead. Well, let me talk a little bit about that barrier, because I think you're right. It is a huge barrier, especially when you are alleging that there is fraud. When you allege fraud in a case in the United States, and the same is certainly going to be true anywhere else, you have to show it with particularity. What that means, that's a legal term for basically saying you've really got to have your ducks in a row. And it isn't enough just to go to court and say, this guy defrauded me. You have to be able to show, what is it that I relied on? Was it reasonable that I relied on it? What particularly was said or done that I relied on? Was it reasonable for me to have done that? It's a very high standard. Now, as I said, when you're looking at an injunction, you've got to go in and show all of that to the court. So whether we get offshore with a Moravia injunction or whether you're onshore with a domestic court, you've got a very high standard. And Paul is right that in order for us to prevail, we've got to be able to show that there is fraud, and at that point, Bigco has to enlist PhoneCo as its ally to be able to say.
That was to interrupt you there, Randall, that was exactly my point. If BidCo wants to prevail in this matter, they need their competitor as an ally.
Yeah, and that's going to be very, very difficult. I mean, because if PhoneCo comes in and says, yeah, we want to enlist with you against this guy, they have now gotten in bed with their own competitor against somebody that may never be able to be levied against. And it may well be that PhoneCo's not going to want to do that. They're going to want to come back and say, wait a second, why should we be getting in bed with BidCo? We've got a good case against them. They should have done their due diligence. They should have made sure that these patents were good. They should have found out. They should have done something, because BidCo is going to have, frankly, the deeper pockets than Mr. Nerd is. So that is going to be very difficult, and especially if you're going in to get an injunction, you've got to be able to show you're going to win. You've got to have PhoneCo's help in order for you to show that you're going to win, and I think that is a very big hurdle. You had something else you were going to add, Paul.
Yeah, I think a couple of other things. Let's talk about the injunctive relief aspect of it, okay?
Sure.
I don't see where you can prevail on the irreparable harm component of a domestic injunction based upon the facts as we got it, because we can point to the fact that this really is a PhoneCo, BidCo dispute. And I'm not saying we'd be successful, but we would make that argument. Further, for you to prevail offshore and try to get a Marave injunction, one, there's a heightened burden of proof on that. It akins almost to a beyond a reasonable doubt. Two, the bond on this will be astronomical, it would be the argument. But three, and more importantly, you have to have, again, a term of legal significance, verifiable proof on that the badges of fraud exist. And I don't know if you can get that. And if you've got that component of it, now Mr. Nerd may have some things to be concerned about. But how fast, how soon, and to what degree, and at what expense can you obtain that type of document, that type of information, that type of testimony? You know, I quite frankly don't know. Further, I think if let's say Nerd is a bad guy, and let's say, for argument's sake, his intent was to defraud, okay? We all know that the $5 million Beverly Hills home, the title in that is now held by some LLC whose member happens to be in what we call an IBC, an International Business Corporation, offshore somewhere. Not that you can protect real estate to any degree of certainty in the United States, but you certainly put up additional barriers there. It's been mortgaged to the hilt, and we've taken substantially all the value out of that prior to the litigation. The $40 million in the Swiss bank isn't there. It's gone. It's been gone for quite some time. The Belizean account, where we have the Belizean trust, that's just a placeholder. I mean, we've got $5,000-$10,000 in that to keep the thing up, but that's about it. And our protector has been moved, as we said, changed pursuant to the instrument. The trustee is different pursuant to the instrument, and also the beneficiaries are changed pursuant to the instrument. And so BidCo's got some big problems, big litigation problems in that.
Let me interrupt you just.
Go ahead.
Let me interrupt you just for a second, Paul, so that our listeners will have an idea as to what some of these technical terms that we're talking about are. When we talk about burden of proof, most people understand the burden of proof from what they watch on Law and Order in a criminal case. And they say, well, wait a minute, you know, unless I can show something beyond a reasonable doubt, it hasn't been proven. Well, it's kind of on a scale. And in a civil case where you've got, let's say, a traffic accident, all you need to show is that it's what's called a preponderance of the evidence, if it's more likely than not. When you are dealing with fraud, you have a heightened burden of proof. I need to be able to show that there is a higher degree. If you were to put it on a scale of 1 to 100, 51% would be a preponderance of the evidence. The heightened pleading standard for fraud would be somewhere like maybe 75. The beyond a reasonable doubt would have to be somewhere around 95 to 99. And you are right. When you get to an injunction, you're probably in that 80 to 90% range. You have to show that you have a reasonable likelihood of success on the merits. And as a result, a lot of courts will require what you refer to as a bond. They will come in and say, well, yeah, wait a minute. If I freeze everybody's assets and, as a matter of fact, you lose, these people are going to be out money. They're going to be out the interest that they could have gotten on that money. They're going to be out whatever investments that they could have made with that money. I'm going to make you come up with a bond. You're either going to have to go out and find an insurance or a bonding company that's going to come up with it, or you're going to have to come up with some money on your own and give it to the court so that if you're wrong, you can make up for the damage that you caused. That also is going to be, as Paul just pointed out, a real disincentive. When Paul talks about the instrument, let's all remember that in my beach analogy, that was just me telling Rob what it is that I wanted. When you actually settle a trust, there is a trust document, and that document will be the instrument. It will be a settlement document. It basically turns out to be a contract. It's a contract between the grantor and the trustee. The beneficiaries have some rights under that, and it can be a very flexible document, as Paul pointed out. And it can be what Paul referred to as the duress clause, which means that if it looks to the Belizean trust company or to the offshore protector that there is going to be a threat to the trust or to the corpus of the trust, they are not only entitled, but they are actually instructed under the trust instrument, that settlement document, that contract, that they've got to move the money. They've got to do everything they can to make sure that that the corpus of that trust, the money that's in that trust, remains protected. That may mean that the trustee resigns. It may mean that the protectors resign, and that there will be some contingencies in that document. I'm sorry to have interrupted you. There was something else I was going to talk about with regard to the protector, but why don't you finish, and then I'll talk a little bit about whether we could even get jurisdiction for a Moreva injunction in a case like this, where you don't have any of the parties other than perhaps the offshore protector, the British citizen, the barrister, who would actually be subject to any kind of a court order from the English court.
Yeah, well, there is that point, and I think we neglected too, on these offshore jurisdictions, a bond is also required to be posted for the other side's attorney's fees, not just a bond to protect if the injunction is wrongfully issued, but, you know, contingency fee cases aren't recognized offshore. Loser pays is commonly the guiding instrument, if you will, and so you have to be mindful of that additional expense. Further, if some type of injunctive relief is sought, okay, I mean, there's got to be some type of nexus relationship, if you will, established that the party seeking the injunctive relief, in this case BIGCO, has entitlement to the money. In other words, they have a right to that money. And their argument is they have that right because of what they say was a fraud that Mr. Nerd engaged in obtaining the money from BIGCO. Well, that's going to be litigated. That's going to be litigated offshore, and that's going to be litigated by, and if it's in a Commonwealth jurisdiction, by Commonwealth lawyers. And those lawyers are going to be charging, you know, in some instances, in some of these jurisdictions, $1,000 plus an hour. And it's not going to be a simple and pain-free exercise, assuming that there is, you know, that someone prevails to begin with. All that time, there is no freeze. All that time, that money is able to be moved and transferred. Now, BIGCO would argue it's able to be moved and transferred illegally, and we argue, no, that's not the case. Because I think one of the key factors here, if I'm representing a party that is being sued in this, and Rob knows this well, in the question, the threshold question, the first question out the door is, does the defendant, in this case Mr. Nerd, have any viable defenses? Okay? Does he have any, I mean, in the past what I call the blue face test, all right? In other words, where I can get in front of a court and not have my face turn blue, okay? In other words, legitimate, sustainable, well-thought, you know, defenses. And if he does, okay, that is an extreme barrier as well to recovery. And it's also an extreme barrier to any argument that the trust structure should be unraveled. Okay? There are defenses based upon the fact pattern we have here. But let's take it to the extreme. If Mr. Nerd is indeed a crook, let's say this wasn't a purchase of an asset for value. In other words, let's say this wasn't involving a patent, and let's say it was an investment scam, a Ponzi scheme, a Madoff type situation. Okay? And everybody, hopefully all the listeners are familiar with that. Okay? That's a whole different situation. That's a whole different set of circumstances. What defenses does he have? He doesn't have many in that instance based upon the facts that the public is aware of, and I don't know any additional details. I'm sure counsel for him has tried to resurrect some barriers. But let's assume there are no defenses. Now, in that fact pattern, Randall's got a whole different set of options and less barriers to penetrate, and can indeed be much more, the likelihood of success, I guess, would be much more readily available to him. But in this instance, I'm going back to the whole domestic structure here with the patent involved and the purchase for value and what have you. We're assuming that Big Coat did their due diligence. It might have been faulty and it might have had problems with it, but nonetheless, they parted with $50 million, dollars, a huge amount of money. And I've already talked about some of those defenses on the conversation regarding all the intellectual property issues, which, by the way, we just kind of that's a whole separate discussion, a whole separate topic, presentation, if you will, about how that would actually come to play in a barrier. But it's a defense, and it's a defense that I would be comfortable if Rob came to me and said, do we have defenses? Based upon the fact pattern, yes, you do. And then the question might be, what do you approximate the success of that? Well, on this matter, I mean, it's a 50-50 at worst. I mean, in part because of the time and the effort and the aggravation and the expense.
Before we go into that, let me just follow up on one thing that you said, and then we'll talk a little bit about the defenses. And it is that the motives matter and the facts matter. I wanted to refer our listeners to two particular cases. Every asset protection planner is familiar with them. One of them is called the Anderson case, and one of them is called the Lawrence case. The Anderson case was a Ninth Federal Circuit case that came out in 1999, and you had some bad people. And they had set up an offshore trust in which they put a whole bunch of money that they had gotten from a Ponzi scheme. And they came to the judge. Well, they made a real mistake, and that was that they angered the FTC, the Federal Trade Commission. And they came to the FTC and said, hey, we not only can we not get our money, but if we try to get it, there's no way that we can get it. It's gone, and there's nothing we can do about it. And the court looked at him and said, you might be right. Your money is offshore, no question about it. It's in the Cook Islands. It was set up there, and that money is put away there. And I can't get to it. I can't force the Cook Islands to cough it up, and there's not a judge or anybody from the Cook Islands who's here that I can get. But you're here. And as long as you're here, I have power over you, Mr. and Mrs. Anderson, and I'm going to hold you in contempt of court because I don't believe that you legitimately put this money in the trust, and I don't legitimately believe that you can't get it back. So while I can't order it back, you can get it back. You can order the trustee. Well, I think that you can, regardless of what the trust instrument says. And I'm going to put you in jail until you do. And he did. And ultimately they settled. Now, it's kind of interesting. They settled for less than the total amount that was in the trust. So I guess you could say that it was a win for both sides. The other one is the Lawrence case, and that was in about 2002. And it was a similar situation. I don't need to go through both of them. But in both of those cases, you had bad people. And I believe that Paul is right, that it is much more likely that you are going to be able to prevail against a bad guy than against at least an arguably good guy. The way Rob set up this fact pattern, Mr. Nerd is not so obviously odious and horrible that you look at it and just say, yeah, that guy ought to be in jail. we ought to just take that guy out and shoot him up against the wall. And Paul is right. That makes my case against him a lot more difficult, because I can't simply storm into court and say, this guy is just as tainted as they come, and he should just be taken out and killed, and you better do something about it.
And I think that's an important distinction here. And that character you're talking about, the bad guy, you know, word of caution to anyone listening, you know, counsel who represents that individual needs to be very, very careful. That's why you got to vet the client out, potential client out, with extreme, you know, caution in any of these situations to make sure you don't have that problem. And then that kind of also goes back to even the introductory comments that we made about the type of individuals, entities, and people we may represent. You know, I don't represent those kind of people. I don't have a stomach for it. I can't be passionate about it, and I don't feel good. I can't go home to my wife and daughters and you know, and say I've had a good day. It just it leaves a bad taste in your mouth. In this case, though, there's a lot of fluidity going around, and quite frankly, practically speaking, is this a case that would beg for a settlement? You know, I don't know if BidCo would take a settlement, but that's something we would offer up with the understanding, being forthright with them. That's all they're going to get. They're not going to get any more. And they may disagree with that, and we could say, fine, you could try, and what we're offering you as a pittance maybe of a settlement is going to be eaten up in the fees that you're going to spend, you know, carting around the country and the world on this, because we do have defenses, because we do have the ability, one, to defend, and two, we can legitimize our positions on this. And I don't see anything in here that on I guess, broad brush scale would invalidate the structure. And Rob said in the beginning, okay, and I wrote these down, the operative terms, it was a well-done and well-defined trust. Well, if that's the case, and we're not dealing with the ruse, you know, competitors out there that set up trust, we're in a pretty good spot. That also brings up another component to the listeners. If you are someone that is looking at setting up an asset protection trust, you need to vet those people out that you are working with. And one thing, and I'm not going to promote Rob to a ridiculous degree, but one thing that I think that's important that Rob has done with all my clients, he makes sure he works with the tax lawyers, the CPAs, the estate planning people, so everybody has an understanding of what we're doing and how we're going about setting up these trusts, so we don't have the threshold attack on the trust structure. And to back out and to kind of backpedal a little bit, we were successful in a matter domestically a number of years ago in almost well, actually it was 100% recovery for our client, and the strategy was to sue completely domestically and do not go offshore, as well as keep it within the confines of the United States. And we were attacking the actual structure itself. And we also brought in all the professionals that were a part of the common scheme and plan, and that worked. In this instance, again, if we change the fact pattern a bit, and it's not a well-defined, well-done trust, and we are talking about a widespread scam, if you will, on this, and we're talking about Mr. Nerd not only is not even the inventor, he indeed did steal the technology. He indeed utilizes the services of patent counsel to commit fraud on the patent office and getting a patent issued vis-a-vis fraudulent conduct by promising them, you know, X amount of dollars under the table. He has paid off the CPAs and the other barriers, and those people have all taken money. Now Randall's got a decent domestic case setting in front of him. And again, that changes our discussion, but I'd like to hear what's your thoughts on that, Randall.
Well, I think you're right. One of the questions that comes up, of course, when you're looking at unwinding a trust structure is, when is it done, and what does the grantor know at the time that it's done? If he knows that Big Co is about to sue him, or even worse, if he decides to set up the trust structure after Big Co has sued him, I'm going to have a much easier way of being able to say that is just simply, yeah, that would be seen as a fraudulent transfer. That's a term of art when you're dealing with asset protection. A fraudulent transfer doesn't necessarily mean that there's actual fraud involved, but it does mean that you are trying to get money away from a legitimate creditor, and courts will regularly unwind those. And if you have that situation, it would be very easy for a court to just come in and say, no, sorry, that trust isn't any good. Well, let's suppose that...
I was going to say, and that's why the threshold question that would be asked by the practitioner is, Mr. Nerd, I got to do my, the KY, know your client, and with the KYC. The KYC component, is there anything threatened, pending, expected? What are your creditors? What are your legitimate assets and debts and things like that? And to evaluate, indeed, are we going to set up a trust that will end up being old and cold, meaning that set up that is indeed for wealth succession and asset planning purposes. And if you have that circumstance, these are very good vehicles for protection down the road for some crazies that come around and sue. I'd like to make one more comment and then let Randall follow up with what we've been talking about. The cases that Randall's referred to, yes, they're well known, but that's kind of like the McDonald's coffee case. And what I mean by that is that I think the listeners, I might be gauging my age, if you will, but those of you that don't know, I might even be 10 years old now, I think. McDonald's got sued by a lady who got, I don't remember the degree, significant burns by spilling coffee on her. And I remember people were in an uproar about how terrible our legal system is that such a thing could happen. And the point is, that's an extreme. That's not the norm. That's not the regular situation that we find in a lot of personal injury matters. And I think the example, Randall, that you gave of the Lawrence case, and I forgot the other one, but I'm familiar, Anderson, those are extreme cases. That's not our fact pattern here as well. I don't think Big Co would be successful in getting a court to order Mr. Nerd to return funds. First of all, they've got to make this, that's a huge assumption that Big Co is entitled to those funds, okay, all of them, or they're going to hold them in contempt. And the second component of that is assuming Mr. Nerd remains in the United States. These days, lots of people like Australia and lots of people like, Italy and Europe and the Mediterranean areas. They're nice places to live. So, there's that component, I think, that comes to play.
I think you're right. I wanted to talk a little bit about the KYC, the Know Your Client. I've always thought it was KFC. This changes everything because usually what I'll do is just go out and get a bucket of chicken. This changes everything for me.
Yeah.
I did want to say something a little bit about that. You're right. Let's suppose that, well, we've got to presume a whole bunch of stuff here. We've got to presume that he wants to stay in California and that in doing so I'm going to be able to get him into court. I think it's going to be a tough row to hoe for me to be able to say, Your Honor, I am entitled to my money back, and I can show that there was fraud not only to me but also to everyone involved in this thing, including everybody that is the potential victim of this guy's estate and asset protection planning. He's going to come in and say, well, no, wait a minute, I was going to get married and I had all of this kind of stuff. I'm going to be able to say, nobody sets up an offshore trust and puts all of their money with an offshore trustee that he doesn't know, especially
and you know
millions.
I'm going to interrupt on that. I think there you go. Now that, and shame on me for missing that fact. It would be different, okay, if in the structure, 60% was moved offshore and he kept 40% or even 20% kept domestically within, to live and start other businesses or do anything else. But the fact is, shortly after getting the payment, 100%, well, $5 million was spent for the home, but like I said, if I'm going to be a jerk about it, I'm going to deplete that. So let's just assume nearly 100% of it has been vacated off of the reaches of the domestic shores here. Now that's a badge there that I think BidCo can make some hay on. Doesn't mean that it expedites and makes their road easy, if you will, but it's an important fact. I think that's something to be made clear to the listeners. If you're involved in setting up these structures and you're advised to move 100% of your assets offshore to someone you don't know, you yourself may be in trouble and being taken advantage of by those people that are recommending that kind of a structure.
Yeah, let's talk a little bit about what are the fundamentals. I mean, what is the idea of a successful asset protection plan? You know, your average listener is going to say, well, the total success of this thing is going to be that I never lose a dime. You know, that if I get sued, I'm bulletproof, and that nobody can ever get to my money. I don't think that that's possible. I don't think that's possible in today's litigation world. I think that if you can set something up so that you have now put a few firewalls between you and whoever it is that's trying to get at you, you put up sort of a moat around the castle and you put up some big high walls, but by the time that they get into the castle, they've spent enough money that they're willing to take a lot less than they would if you hadn't put those up. To me, that's a good asset protection plan. So if I have a client that comes to me and says, you know, I've read all this stuff and I think that there's some bulletproof way out there, regardless of what it may be, and there's been a lot of scams that I've seen over the years. You know, there's the, I call it the combo platter, where it's a, actually it's not my phrase, it's actually a phrase of Jay Adkison, a friend of mine, you know, where you've got the family limited partnership and an offshore trust combination, or something that Adkison is not big on either. I don't want to make it sound like that's something that he promotes. Or you've also got, you know, the bulletproof Nevada trust, where you're going to have some sort of a designee and a nominee president, and you're going to be able to hide all that kind of stuff. You know, and you'll have a client that comes in and says, I've seen all of this stuff, and if I'll just buy into that, nobody can ever get a single dime of mine. Well, if that's the anticipation, I can't help you. The best I can do in an asset protection plan is to make sure that you are going to be protected for some of your money, and I'm hoping the majority of your money, and I'm going to be able to put you in a position that when somebody goes after you, it's going to be hard enough for them to go after you that they will take less money and will not completely break you. To me, that's a successful asset protection plan, which leads to that question that Paul brought up. Would this be a case that would be right for settlement? Now, I'll bet that of the cases that I handle, probably 90% of them settle. Very few of them actually end up in court. And the reason that you want to go to settlement is because I've always said a bad settlement is better than a good lawsuit, because you go into a good lawsuit and you never know how it's going to come out. I can't predict what a jury or a judge is going to do. They may award $1 million, they may award $0 and go after you for costs and fees. So would this be a case that you would say to the board, if I were representing BidCo, let's think about settling this case? The answer to that would probably be yes. There would be a point where you'd say, yeah, let's settle it. Let's get something out of it. There's no way we're going to get our $50 million back, but we might be able to get half that back, and we might be able to, you know, we might be able to get even a little bit more. But if we insist on going forward, we take the chance of getting $0 back, or we can get maybe more than that. Maybe we can get $30, $40 million, but we're going to spend $15 to $20 million to get there. And so you get to the point where you just have to kind of say, where are things? You know, I could probably prevail on different facts than the ones that we've got. I could certainly lose on different facts than we've got. On the facts that we've got, you know, if someone were to say, what do you think the chances are that you're going to totally prevail? My guess would be probably what Paul just said. I think at best 50-50.
And you know what, Randall? As a defendant, I like those odds. As a plaintiff, those aren't good.
That's right. That's right.
You know, and I think too, and those of you that are listening to this thing, if you're still tracking with us as we go through the analysis, I think hopefully you can appreciate the fact that, I mean, really, the term of art being a sliding scale, if there's anything that's a sliding scale, these types of situations are it. Part of it also depends, unfortunately, upon the quality of counsel that you engage. And I'm not saying this to do a plug for Randall and I, and quite frankly, far from it. What I am saying, though, is if big fancy law firm, international law firms hired by Big Co, and they're getting a multi-million-dollar fee payday, and they could do everything under the sun, unturn every stone, et cetera, they're not going to think practically about it. And in fact, the embarrassment on the board of Big Co may prevent them from doing anything different if Big Co is publicly traded at all. Further, if defense counsel is unscrupulous, that makes things even, far more difficult. So please understand, those listening, the discussions that we're having here with Randall and I, we forgot to probably tell, we told you up front, I think, we're ethical, great guys. But beyond that, the analysis that we're doing is an analysis that assumes you're dealing with good, competent, aggressive maybe, but good, competent, upfront, forthright counsel. Certainly, listeners can take this fact pattern, our discussion, ask 10 different lawyers what their opinions are about what we're saying, and you'll get 10 different opinions from those 10 different lawyers. But I always like to use the phrase, is what's the best practices? And what I would say and pose to you listening out there, that what we're discussing and how we're going through the analysis, I believe, based upon my experience, and I'm not going to speak for Randall, but I'm going to assume he's going to say the same thing, this is the best practices in the analysis of a fact pattern such as this. And finally, I think if we look at the issues on who to sue, where to sue, theories, and what are your expectations, to kind of address that for a second. On the who to sue, and now I'm pretending I'm Big Co, but I'm representing NERD, and I may want to try to divert some of this or bring in third parties. I don't know. It depends upon what the details show. But look, Mr. NERD did not do the IP procurement, the intellectual property procurement on his own. So you got policies with the patent counsel on what they did. Sorry, lawyers that are listening that may be patent counsel, but you're a target. That's why you got an NYC as well. Okay, to do the due diligence, the prior art analysis. We want to see what the file wrappers say at the USPTO office, what the office actions had, were there rejections, was there information that was misleading to the patent office. And I think so they're a target. Certainly, those practitioners out there that do the estate planning work, that potentially is a target in addition to the patent people. But here's the problem, I think, that Randall would fall into if he represents the entity. Okay? The entity is governed by a board which votes in the officers. Someone, something, some committee approved of the $50 million hit. Okay? I think Big Co and those parties within Big Co have a conflict with each other. And I think those are all targets as well. Who ignored what? How did this happen from internally within the company? And I think Mr. Nerd would be well served to, again, divert attention away from him, because he's got problems. He's got not problems. He's got problems for Big Co to recover. And, is there D&O coverage within Big Co? What other insurance carriers are around? And I've tried to collect in some of those things, too. It may not be within the board's best interest or the officer's best interest, but Randall doesn't represent them. He represents the entity, and really, he's at the beckoning call of those shareholders, who should be very, very torqued off and upset that this transaction went down, and now they're trying to blame Nerd when Nerd can't be found. So that kind of goes into the who to sue, where to sue. That keeps it domestic. We've got good theories, and we've got pockets that we can look to. And if you go on the final one, I'm kind of playing a little bit on the Randall's role here, but I'm doing so because it benefits my client. Understand that. The expectation is that's more likely to get a settlement. I would do anything and everything within my power to divert attention also from a full mounted, full assault, if you will, against Mr. Nerd, and basically explain you know, you're going to be going offshore. You're going to be going to Belize. You're going to be going to the Cook Islands. You're going to be going to Britain. You're going to be going to Guernsey, Jersey, blah, 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 blah. Why bother doing that? Look domestic. There's all these other bad players, bad apples that are involved.
I think that's an excellent point. And Big Coast folks do need to be looking over their shoulder. I mean, there may be some sort of a derivative suit that's going to come from one of their shareholders. I don't know if I remember whether this was a public company or not, but they're also going, let's presume that they are. They've also got all sorts of SEC issues that they've got to look at as far as compliance. So you're right. If I were Mr. Nerd, I would be looking around saying, you know, kind of pointing my fingers both ways and saying, hold on just a second. You know, it's not much of a defense to say, yes, I robbed you, but you let me, and so you are negligent. But that wouldn't be his position. His position would be, wait a minute, everything that I did, you did your due diligence, and you did okay on it. I don't know why you're looking at me. I didn't steal anything. Everybody signed off on this thing. What are you talking about? I got away with your money.
And that's you know, we talk about Randall. What defenses are there? That's an absolute defense on them piercing and unraveling that offshore trust.
Yeah. Yeah, I agree. Well,
may I ask a question of each of you?
Sure.
I'm loving what you're saying. I want to know, Randall, you thought you might get Paul's client to give you $25 million to settle. And you thought maybe 25 to 30 would be a good result for your client. Paul, what are you willing to pay?
I just threw that number out there.
Yeah. Well, no, but I think that's a fair question in some respects because, you know, you got to look at this for a complete and total absolute release and taking control of my own destiny, not having to pay my lawyers and the aggravation and everything else. I'd probably offer up $5 million, be willing to go as high as 10, and let them know they got the other opportunity to recover with the other 40 with other parties. Or I would probably have a very candid conversation with Randall and say, you know something, there's nothing stopping that derivative action. You guys really made a mistake. Now, granted, we may have some culpability, but it's not 100%. You really made a mistake here on that due diligence on what you did and not doing your own investigation. It'd be different if we withheld something. It doesn't appear in the fact pattern we withheld anything, okay? And, you know, to buy peace in that sense, that would make some sense. You know, that makes justification because, as Randall pointed out, you know, any lawyer, another word of caution to the listeners here, okay, in my humble opinion, any lawyer that's eager to go to court, in my opinion, is a fool. Either they have not litigated enough or they're a liar. To be very bold with it. Good litigators want to avoid court for the reasons that Randall talked about. The uncertainty with judges and juries is extreme. And to be able to talk to Mr. Nerd, okay, and assuming he's not narcissistic and his expectations are not, as Randall spoke of earlier, where he's going to, you know, protect 100% of his assets. Okay, my pitch would be you're taking control of your own destiny and not letting it fall in the hands of some third-party decision maker. Number one, okay, and number two, the definition of a settlement is you're always mad at your lawyer because you did it, but at, you know, a year, 6 months, whatever time frame later, you're very pleased that you don't have the problem. So
I agree.
Yeah.
I agree. I got to tell you, my definition of a good settlement is where everyone is equally unhappy. Nobody's going to feel that they got the best deal possible in a settlement, especially 5 minutes after it's done. The plaintiff is saying, I can't believe that I didn't get everything. I was wronged. I should get every dime plus attorney's fees plus interest, plus I think the guy ought to be taken out and shot. The defendant is saying, I didn't do anything wrong. I can't believe I came up with any money whatsoever. This is wrong. It is morally wrong. These people are just a bunch of chiseling jerks. When everybody in the room feels basically that same way, you've probably reached a pretty good, fair settlement for everybody, at least to the point that everybody has now taken control of their destiny. They can shut the door on this, and they can go on. I mean, in this case, if it were settled, Big Co is going to sit around and say, we got robbed. That guy stole from us. And Mr. Nerd is going to turn around and say, I can't believe I had to give anything up. It was negotiated fair and square, $50 million. They just happened to have buyer's remorse, came after me. I can't believe I had to give anything up. And, you know, if it does settle, probably everybody's going to be equally unhappy, and in the end, everybody's going to be equally served.
Well, I mean, think about it this way, practically speaking. If I'm shareholder representative here, BitCo, what are you thinking? One payment for $50 million bucks? Are you crazy? Why didn't you structure this thing out? I mean, who gave you that authority? Are you nuts? Hello? That's why you make a good faith payment of 10%, $5 million bucks. I mean, look at the difference in the fact pattern at that. And then we've got Phonco coming in. Now we're talking a whole different set of circumstances and a whole different set of analysis and strategy. I mean, my goodness. And I think Nerd's got a good position on that, saying, yeah, they were crazy. What can I say? I mean, they paid me that $50 million bucks. I mean, that, you see, what I think is kind of unique about the problem Rob created is, but sometimes it's well versed in fact. I mean, there's just again a sliding scale, lots of different targets. For one to assume Mr. Nerd's the only target, I think is being foolish. Number one, in this fact pattern, and two, you know, fortunately or unfortunately, you know, these things happen, and transactional counsel doesn't think down the road that there's going to be litigation. That's why, quite frankly, another freebie, if you will, for the listeners, I would suggest if you ever get involved in big transactions like this, and Mr. Nerd's lawyer is great, he got the whole payment, but if you're representing the entity or you're buying something, the right hand, the transactional lawyers, must involve the left hand, the litigators, in what these agreements mean and how they are outlined and what they say. I mean, does the purchase and sale agreement for the patent include an arbitration clause? If it does, now we're talking about a different set of circumstances because of the recognizability of arbitration awards internationally. That's another lever that would be extremely valuable to BitCo if that was negotiated. If Mr. Nerd's lawyer permitted that to be in there, is that negligence on Mr. Nerd's lawyer? Well, probably not in this instance, because if he says, I'll give up the arbitration, you can have that arbitration clause in there, but I get my clients $50 million bucks up front, and if we didn't have the arbitration and it'd be paid over time, that's a pretty good deal too. So
let me just put in, we're probably running fairly close to being done with time. There's two things I wanted to say. The first one was that Paul is right. The devil is in the details when it gets down to these agreements. I've got a little article on my website. I've done a couple of presentations about this, both here and also in Brazil, about the kind of boilerplate that you find in these agreements. Usually your attorney will say, oh, that's just the standard stuff. You don't need to worry about that. But that's usually what comes back to bite you where you don't want to be bitten when everything goes wrong. An arbitration clause, a choice of venue clause, a choice of laws clause, all of that kind of stuff is really important. There was one thing that I promised to get to that I just wanted to follow up on, and then I think we can probably quit. It might be just a technical thing, but when we're going in for a Mareva injunction or any kind of an international injunction, you've got to choose your forum very carefully. If you're trying to get a Mareva injunction under British law, you've got to find somebody who's actually going to be subject to British law. Under these circumstances, if you look at that graphic that talks about the trust, the only person there that is actually subject to British law is going to be the offshore protector. Well, you know, is it going to be worth it to go in and get them? Maybe not. I mean, I guess you could possibly get Belize Bank and say that's a Commonwealth country, but Belize is really, really, really resistant to taking orders from anybody on anything. But when it gets down to trying to get an injunction, you got to be very careful. There was one other thing that I was going to talk about, and that is you've got the legal stuff that we've been talking about. You also need to look at some of the kind of practical stuff. It may well be that, you know, you can't go in and under Swiss law necessarily get an injunction, but it may well be that you could sit down with the president of the Swiss bank and say, you know, it would really be to your advantage and to everybody's advantage to, you know, freeze these funds, and I can give you some sort of a legal basis for you to do that. because we're in the middle of a big hassle. I know that Rob, for example, actually knows some folks in some of the international banks. I'm not sure that they necessarily always listen to our advice as to what they should do, and they, of course, have their own fiduciary duties to their depositors and to their shareholders. But there's also kind of a political / personal aspect to this as well. Anyway, I would just wrap up and say, if we're at the point that we're ready to quit, that if I were to look at this case, if someone were to bring this case to me, I would probably be happy to represent either side. I think that we've looked at it and said there are adequate issues here for either side to look at, and I think that ultimately it probably would result in some sort of a settlement, in which case you could say, well, the asset protection aspect of it did work. You would also say, you know, the claims did work, and where everybody is walking away saying, I lost, and they also walk away saying, I won, you've probably got a pretty good outcome.
I think that would be the correct assumption and conclusion, with the caveat being if Mr. Nerd was a reasonable individual, and we don't know that. That's the assumption there. And a lot of times that is not the case, and maybe we wouldn't have a resolution. But nonetheless, I think the listeners get the flavor of what we're talking about. You know, that typical lawyer answer. It depends. And that's why when someone asked me a while ago, you know, gosh, you've been doing this for over 20 years. Hasn't it, you know, gotten boring for you? Well, I'm very fortunate in the sense that, you know, I don't do a particular standard cookie-cutter practice, and every day is different. And every day, you know, results in an it depends answer, because the analysis is very dependent upon the facts and how you apply those facts to a sliding scale of law and a sliding scale of you know, interplay between parties that changes in some respects how that law is applied. So I think, again, for my concluding comments is, if you take nothing away from listening to us jabber on for about an hour and a half, I hope you take away from this component, and that is, it is crucial, paramount, that if you find yourself in a situation like this, to really have a factual analysis done very, very early. And I think, too, if you're listening and you don't have yourself in this situation, but you're thinking about doing, you know, some type of structure, you know, to make sure you vet out, if you will, every kind of issue you can think, even if you don't think the professional who is helping you needs to know, they do. Because they, you know, finding out something at the back end or after the fact will only do one thing, and that is, you know, cause you more grief and more harm at the end of the day.
Okay, this is Rob. I'm going to ask you each to comment on one more thing, and then I'm going to thank you with all my heart. If Mr. Nerd had just put his money into a domestic entity and relied upon charging order protection, or if Mr. Nerd did a domestic asset protection trust in Alaska or any of the states that have authorized it, would it change the analysis?
Yeah, it would for me. I believe that domestic trusts are easier to break. I believe that domestic structures are easier to break simply because a court here has jurisdiction over them. That doesn't necessarily mean that they are going to be weak just as a matter of course. I mean, I think that there are some good domestic structures out there. But I got to tell you, it is much easier for me to make a case that, you know, Your Honor, you've got jurisdiction over this. You can unravel this trust. You can get into this LLC. You can do all of that kind of stuff. It's easier to make that case than if we're dealing with an offshore structure. And despite the fact that I could make the argument on Bidco's behalf, well, wait a minute, the fact that he's got an offshore structure is indicative per se that there's some sort of fraud involved. That, I mean, that's only going to take you so far. Even if you prevail on that kind of an argument, you still have the fact that the money's not here. When you have a domestic structure, the money is here, and I think that it gives the plaintiff a lot more flexibility in trying to get to it.
I would agree. But on the same token, for whatever, whether it's justified or not, I think there's a perception within the United States that if you do anything internationally, there's a presupposition that it must be a fraudulent intent. I'm just talking from a layperson perspective. I think that is wrong, but nonetheless, that's kind of the flavor that you get. So domestically too would also enhance the perception of others that, okay, he's not so bad, as he'd be much worse if he goes to one of these little dinky countries where all they do is, hide bad people's money. Anyway, that's kind of my concluding thought.
Yeah, and I would say there, the fact that under these facts you've got Belize involved. Belize has already been cited in court cases where they've said, Belize really doesn't have that much credibility out there. And at any given time, there's going to be some jurisdiction or other that's going to be under the microscope. It may be Belize, it may be the Cook Islands, it may be the Cayman Islands, it may be some other deal. I think Paul is right there. So Mr. Nerd, if he could go to the court and say, no, the legitimate reason for which I went offshore was not just because I wanted to keep my goods out of the hands of somebody. There are certain, there are certain investments that I can only make offshore. There are certain types of funds. There might be mutual funds that invest in different kinds of offshore stocks that I couldn't get to if I were doing it through some SEC-regulated mutual fund here in the United States. If he can come up with that and legitimately sell it, I think he's got a better chance. Not necessarily always a winning chance, but he's got a better chance of making that seem a lot more credible.
I would agree. And what's unfortunate though, a lot of the the whole to be current, the Occupy Wall Street argument, the 99% and the 1% deal to keep things current. Okay, because today is November 3rd, 2011. So people listening to this, years from now, reflect back on this. But I think illusion is that anyone who does, international transactions got to be involved in something that has some impropriety. Well, nothing further can be the truth from if you look at the structures probably, if you will, at least people I know that are in that 1%, they're diversified their portfolios internationally. So it's just a stigma, but it's a stigma that exists.
Yeah, and as I said, you're going to get a judge who's making whatever it is that he makes on his government salary. You're going to have 12 people in the jury box who are not necessarily going to have a lot of investments. I mean, their investment is going to be in their kids and their car and their house, and they may neither understand nor, for that matter, be very sympathetic to somebody who comes in and says, hey, I've got this diversified portfolio that requires that I have money offshore. They're going to just roll their eyes and say, yeah, right, you're just trying to keep it out of the hands of people that you owe it to.
Exactly. It's not a good jury trial for Mr. Nerd.
No.
Guys, this has been beautiful. Both of you have really helped our listeners and me. I really, really appreciate it very much. And anybody listening to this, at least if you're listening to it and watching it on the Asset Protection Training website, down underneath the video you have a place where you can put a comment, which will be going to Paul and Randall. Any questions you ask or comments you make, you can be sure they'll see. Ask away, guys. We really want to know how this works with you, whether this is valuable to you. You can contact Paul or Randall under the information at the faculty tab above this, and please let us know what you think about this. We'll do more and more if the feedback is that this is helpful. Thank you very much for coming and for listening, everybody.